All right, folks, we got a real treat today. If you've been following the Murdaugh murders, crime, and corruption saga, you know our guest today. You're a veteran here, Steve Sumner.
Thank you. I don't know if I deserve that term or not, but it's always a pleasure to visit with you, Will.
Well, man, our audience has benefited from your insights on several occasions in the past, particularly the boat crash,
Right.
that seminal event that really launched this entire
It did.
crime and corruption saga, didn't it?
It did. The boat crash is really, as you said, the genesis of everything, because that's when you had the allegations, Will, of potential obstruction of justice and things of that nature, where it left the solicitor's office in Beaufort County and it went to the Attorney General's office, and then unfortunately it wound up with 2 people being killed.
That's right. And the Murdaugh murders from June 7, 2021, we are now just days away from the trial, the double homicide trial of Alec Murdaugh, who stands accused of killing his late wife, Maggie Murdaugh, and younger son, Paul Murdaugh.
Right.
You followed this case from the beginning, Steve. What, as we prepare to start putting a jury together and actually gaveling this trial to order, what's one of the big things you're looking at here as we start that jury selection process? Is that the first key hurdle here?
It is. There's been some pretrial motions, Will, that we'll talk about that's been filed by both parties, I believe. But jury selection is a critical part of any case, civil or criminal. In this case, they have the clerk of court's office in Waldoboro in Colleton County has summoned 900 people.
And big group.
That's right. I'm not sure they can fit 900 people in that courtroom. I've tried about 20 or 25 cases in that courtroom years ago. And so they got 900 people. It will be for our audience, it will be a long and lengthy process. You have highlighted some things in a few articles that you've written, Will, about the extensive questionnaire, which goes beyond the norm. Generally, in a case, the judge will ask 7 or 8 questions, such as, basically, can you be fair? Do you know anybody involved in the case? Have you heard or read anything that would keep you from being fair? Can you give the state and the defendant a fair trial? Can you be neutral until you hear all the evidence, until you hear everything, and then make a decision after the jury charge? The questionnaire in this case, Will, went far beyond that. It went into, what do you watch? Are you a member of any organizations such as Mothers Against Drunk Drivers, Students Against Drunk Drivers? Do you watch Dateline? Do you watch 48 Hours? How do you get your news? Where do you get your news from? We have the element of social media, and often social media outlets are not neutral. They have a bent one way or the other. And so if somebody gets their news from, I'll just say Fox News, because that's known as a pretty Republican and that leads or lends itself that way, that tends to show you're more of a law and order type person. If you get your news from maybe the New York Times, maybe you're on a different slant. So they're going to ask a lot of those questions, and it's going to take a long time. I would not be surprised to see it take a week.
A week?
I would not be surprised.
So the first week of this trial that everyone's been waiting on, the trial, you're telling me the trial might not even get started until the
I wouldn't bet on it. I wouldn't bet
really?
on it. No, I think, well, first of all, we got 900 people. Now, let's talk about something very unique in this case, and that is the venue, which is Colleton County, which is a part of the 5 counties that the Murdaughs were over.
The 14th Judicial Circuit.
Right, the 14th Circuit for 100 plus years. So you're going to have a lot of people, I suspect, and I don't know, that will probably try to excuse themselves from it because they have a relationship with the family. Maybe they don't have one, but my mom did, or my dad did, or my grandfather did, or my grandmother did, great-grandfather. That's how far they go back. I know you and I have talked about that before. So you've got that factor involved. You've got a tremendous amount of pretrial publicity. Some people are going to play that card and say, I don't want to be a part of this. However, critically, do they feel a debt of gratitude from something in 1965, from something in 1985, from something in 95, from something in 1940, where I need to be on this jury, I need to do this? And it cuts both ways. And I think this is where both Richard, I call him Richard, Dick Harpootlian, and Jim Griffin, 2 excellent attorneys. And I just want to say, the legal teams on both sides and the Judge Newman. I mean, this is the Jordan Bulls of the South Carolina bar. I mean, this is what we're talking about. We have some excellent attorneys. I'm not going to need to continue to say that. I just want to put that out there. It cuts two ways. One way, I owe a debt to this family because that family was powerful and they helped my cousin when I needed help. They helped my sister-in-law when she needed help. Other people, it's time for this to end. And you just don't know. And that makes the venue of this case, which is Colleton County, that makes it a very interesting question, because I believe that a motion or a pretrial motion to move the case because of publicity would certainly have the basic grounds to make the motion because there's been so much publicity. I don't know where you could move it to where there hadn't been, but they're going to want to stay down there. And I mean, I don't think that that the defense attorneys have given any serious entertainment to moving the case. I'm sure it was discussed, you know, of course, in a conference room or whatever. But I think they're going to play their cards there. So we've got jury selection, which is critical. It cannot be overstated. You know, you and I have talked a little bit off camera before, and political things now, when you talk to folks that do this for a living, they say it's not about swinging undecided voters anymore in a Senate race. Let's talk about maybe Herschel Walker and the gentleman that he lost to in Georgia, Mr. Warnock. It's not about changing people's minds. It's about getting our people to the polls. That actually transposes very well to this trial.
Really?
Yes, in the respect that, can we change people's minds? Mm-hmm. Or do we need what they're going for, what they're going to try to do is get people that are predisposed to hold the state to a very hard line. Mm-hmm. And the prosecution is going to want people that are predisposed to, the evidence is there. My job, the judge is going to read the jury charge. We're going to talk about that in a minute. And I'm going to convict him. And so there are so many dynamics. We could talk, and I know we're not, we could talk for 8 or 10 hours about this.
It's a fascinating comparison, though, but it's interesting, though, when you mentioned that election dynamic. In this particular election, it only takes 1 of 12. So it's a very small percentage that the defense has to turn out, isn't it?
It is. Now, I've tried about 500 or 600 cases. Mm-hmm. Rarely is one person able to hold out that long. Mm-hmm. Now, I have had cases where I've suspected that there have been 2 or 3 people that wanted to rule for me, and I'm a defense attorney. They can get worn down. They can be something called an Allen charge, which I'll talk about in a few minutes, that the judge can give. But one person can hold it out and have a hung jury. But it is pretty rare.
In which case,
I'm not going to say it won't happen. In this case, if the case will be tried again, I would feel confident it would be. I don't think the public, Mr. Wilson as Attorney General, I don't believe the public would accept an agreement reached after a hung jury. I think they would just say, we'll just do it again, is what I think would occur.
Right.
You know? And whenever it happens, whenever it happens. I don't see him losing political, as again, we go back into, because law and politics there's a marriage there. And I don't believe that he would run the risk of alienating voters over not proceeding should the case come to a hung jury. They got to get 12 jurors. Okay, mm-hmm. In magistrate court in South Carolina, it's 6. Mm-hmm. In general sessions, where this is, it's 12.
With 4 to 6 alternates.
Right, mm-hmm. There's going to be 4 to 6. I would not be surprised if Judge Newman had 8. I mean, our Supreme Court over the years gives a lot of discretion and latitude to the circuit judge. And as long as their decision is justifiable and is based upon considerations that will be placed upon the record, I'll talk about that in a minute as we talk about how the case will play out and proceed. I wouldn't be surprised to see him have 8. I just wouldn't. I mean, the case may go on for quite some time. And I'll talk about that a little bit more in a minute. But jury selection is going to be important. It's boring. Mm. Let me get that out there. It's boring.
Apparently time consuming.
It's time consuming. You if you're watching it, You're watching people get asked the very same questions. Juror number 31, come in. Same
Yep.
juror number 32. They'll have experts, jury selection, jury qualification experts on both sides. That'll be whispering. They'll be taking notes. You'll see that pad you've got there. We'll be passing it back and
Peremptory
forth.
strikes.
There it is. Strike it.
Yep.
We're going to rank them. We're going to give them an 8 out of 10. We're going to give them a 6. We're going to give them a 4, and that process will go on until a panel is formed. Now, once they go through the 900, and of course there'll be people that have been summoned that are over 65 or maybe have physical infirmities or something of that nature, so that number will go down. But ultimately they'll become a panel, and I mean the panel may be 50, 75, 100 people. And at that point, the actual selection process will begin. There will be a lot for our viewing and listening audience. There'll be a lot of whispering back and forth at each table about what they think of this person. You're going to see, where did we rate them? Where did we rank them? Should we strike them? The defense has 10 strikes. Now, I want to clear this up for our audience, that you can't just strike a person for no reason. There was a case called Batson versus Kentucky, and that dealt with an African American who was, I don't have all the facts in my head right now, but it was announced by the Supreme Court when they heard the appeal, you cannot strike someone based purely on their race. Then it was moved to gender, okay? So you can't just strike, you've got to have an articulable reason for why you're striking somebody, but it doesn't have to be ironclad. I mean, it can be kind of in the gray area, but the state has 5, the defense has 10, so that's 15 if all are used, okay? And then you've got 12 jurors, and then you have a new set of strikes for the alternates. So that process will take, I think it'll take about a week.
Wow.
It could take less. It could take a little bit. It could take more. Okay. It could.
Well, let's talk, because I know you've been reading these pretrial motions, and there've been a flurry of them since last fall. I think we were talking about was when it started.
Right.
And that gives us a glimpse of where the trial could go.
It does.
Obviously, there'll be surprises. People have got some aces up their sleeve.
Sure.
But walk us through a little bit. Once we've got a jury, obviously tell us first what they're charged by the judge.
Right. They're charged, basically, they're asked to stand up and swear or affirm. We've kind of gotten away from some of the biblical principles that governed our judicial system a century ago. They're asked, can you well, and I used to quote it, can you well and truly try and listen to all the evidence presented and be fair and impartial and render a fair and just and true verdict, so help you God?
And they
raise their right hand, they sit down, the trial begins. Going back to pretrial motions, they really are, I know there's been some articles written about, does this pretrial motion help a certain side when they file it? Okay. Well, really 2 main points there. The biggest point is the judge wants to get rid of as many contentious issues as he can, Judge Newman, who is a fine judge and a strong man. I want everything that is you all cannot agree upon to be brought before me so that I can make the decision, so there's not a trial by ambush. Now, I could talk for several hours about trial by ambush, and we don't like it. We don't want it, okay? We want all sides, I'm speaking for the judiciary right now, we want all sides to have as much information as possible. Why? To settle the case. Court time is valuable. We know how long the dockets are. So we want all of the information to be exchanged so that if a settlement can be reached, it can be reached. Okay.
A plea deal.
Right. Yeah, a plea deal. And then people look down upon that. And of course, I'm a defense attorney. When you hear the term plea deal, it's a compromise. Okay. It's no different than you and I going out and buying a car together and seeing how far down we can get somebody. It's a compromise. They're not going to give us the car, but we don't want to pay $60,000 for it either, so we try to come to a number. A lot of compromises occur, but pretrial motions primarily govern the evidence that comes into the trial, so that the attorneys will know the judge has already ruled this is not coming in.
And there's some significant evidence that's been raised.
And we'll talk about that in just a second. And so that's the number one thing. The second thing is, yes, if somebody reads about a pretrial motion about maybe blood splatter evidence, which we'll talk about in a second, does it give them reason to say, that's a bunch of hogwash? I don't believe that. Okay. And meaning that's not going to affect my decision. They're presumed to be not guilty. I think they're not guilty. I'm not listening to that. So there can be a background reason, but primarily, in my experience, it's done to winnow it, if that's the proper term, to get the playing field as narrow as possible where there aren't any surprises. Judge Newman's goal is for no attorney to be surprised. This is what's coming in. This is not coming in as you go down the list. The pretrial motions, again, we talked about, I believe I mentioned blood splatter.
Mm-hmm.
There are two things that I hope to clear up for the audience on this point, and that is there's something called Rule 5 in South Carolina. South Carolina Rule of Criminal Procedure number 5, which basically says that the state has to share their file with the defense in a timely manner within 30 days after the motion is filed. It would be videos, it would be audio recordings, it would be incident reports, it would be reports of blood alcohol, it could be ballistic reports, that's what you see. Notes are generally excluded. Police officers' notes are generally excluded. But that's what Rule 5 is. It's sometimes confused. A Brady motion is a totally separate animal. Totally separate. There was a case called Brady versus Maryland where the prosecution's office had information in their file that showed or gave a likelihood that the person was not guilty. And I believe it dealt with a physical description. I mean, there were 2 or 3 witnesses that said this person was 5'7", 150 pounds, and the defendant was 6'3", 225.
This is exculpatory versus...
Exculpatory,
right.
Thank you, exculpatory. And until this decision, Brady versus Maryland, that did not have to be turned over.
Wow.
But the Supreme Court, our U.S. Supreme Court, said no. You have to turn that over to the defendant if there's any exculpatory evidence. So people talk about, Brady, it's 2 separate things. A, it's your file, and B, it's anything within your possession, custody, or control. Now that brings up another question. And that is, generally, the Attorney General controls SLED. So it may not be within my possession, but I can control that agent to get them over here to provide this information. It has to be turned over. So when you look at the blood splatter motion, how was it taken? I mean, what quality controls were there? Everything, Mr. Harpootlian and Mr. Griffin want to know every single thing about how this test was conducted, when it was conducted, under what circumstances was it conducted, what procedures were used, what protocol was used, voluminous amounts of information. A, so they can see how it was done. B, so that most likely their expert, in this case it would be Alex expert, can review it and say, I'm prepared to testify that it was not done correctly. Mm-hmm. Okay. And so that it all kind of ties together with the Brady motion and with the pretrial motion. Pretrial motion is specific. In this case, the blood splatter evidence. I think there's been some other, I believe that Mr. Harpootlian had a motion and Mr. Griffin about getting cell phone data and some, very extensive about hitting a tower and this type thing and all of the records that are involved there.
Geocaching.
Exactly.
Geofencing.
Sure. Right,
all that.
right. So that they can examine it, and really what they're doing there is A, doing a fine job, and B, we want our people, our team of experts to see it so that they can examine it and be ready to testify. But the threshold question is, is it going to be admissible? And that's what the pretrial motions are designed to do. Is this coming in? Is this not? Sometimes Judge Newman, as I'm sure you've noticed, will rule from the bench, meaning I'm making a decision right now. Other times, I'll let you know in a week or two. Okay? I need to look at this. And typically what goes along with that are briefs, are legal briefs, legal arguments, 30, 40, 50, 100 pages long about why something should not come in, why it should not be admissible. The same is filed by the Attorney General about why it should come in. And then the law is cited. And in this case, it came in. And in that case, it came in. And they make their arguments. Then they're allowed to make oral arguments. And I hope I'm not going off on too much of a tangent. Oral arguments. Well, I'll hear that again. I mean, I've had pretrial motions where the judge has said 2 or 3 times, we're going to hear it. Well, I won't hear it again. I want you to tell me again about what your position is on a real close piece of evidence. And so you're going to see that. There were pretrial motions. Our audience needs to know there'll be motions filed during this trial, and they can be verbal.
While it's happening?
Yes.
Okay.
And, you know, the state may call John Doe, and it's already been the subject of a pretrial motion that maybe Judge Newman hasn't ruled on. And you may hear him say, ladies and gentlemen, we're going to take a break for the rest of the day, and we're going to come back in the morning because I'm going to make a decision this afternoon regarding something.
On that mid-trial motion?
Yes. You may see 5 or 10 of them. And it can happen all through the trial. And so that happens. But it starts with opening statement. Once you select the jury, Mr. Harpootlian and Mr. Griffin will decide. Generally, only one attorney is allowed to make a statement for one party. Okay. Mm-hmm. So they'll decide who does that. That, you know, I think it was Billy Graham that said, you know, people aren't listening after 15 minutes or something like that. I think they'll go a lot longer than that. Okay. It is started by the state because the burden of proof is on the state. And I want to, you know, talk about that in a second too. So they give their opening statement. The defense gives their opening statement, setting the scene, talking about what points they believe will be key in the case. Now remember that what an attorney says is not evidence. And Judge Newman will tell the jury that. He'll say, ladies and gentlemen, we're getting ready to hear from the attorneys. What they say to you is not evidence. It is merely their opinion or their thoughts or what they want to convey to you, but that is not evidence that is coming in. This is just something that is a part of our process. And so they will get up, they'll make their opening statements. Each side obviously will be taking copious notes on what the other said about where this is going. And then the evidentiary phase, of the case starts. The state proceeds first. Again, they have the burden of proof beyond a reasonable doubt. What does that mean? Well, in South Carolina, we had a Supreme Court case many years ago that defined reasonable doubt. And they said it is a doubt which would cause a reasonable person to hesitate to act. Okay, that is the definition. It is a reasonable doubt is a type of doubt that would cause a reasonable person to hesitate to act.
And in this case, act being convict.
To convict, correct,
Okay.
Exactly. And so what I've argued numerous times is if you have a hesitate, you don't have to stop. If you think about stopping, if the thought of stopping crosses your mind, then our Supreme Court has already told you what the verdict is. The verdict is not guilty.
It's not guilty.
Now, in federal court, it's defined a little more favorably to the government. And it says that basically the government does not have to prove it beyond all doubt, only beyond a reasonable doubt. And if you believe that there's a real possibility that this defendant is not guilty, then that should be your verdict. However, you must believe that there's a real possibility that they're written, and that's a better charge for the state.
Mm-hmm. That helps
So,
the state. Yeah.
In the trials I've been doing in the last 10 years, the judges read both of them.
Yeah.
Yeah, they'll read both of them. So that'll happen. The witnesses come up. The case itself will have a lot of witnesses, that are going to be kind of boring.
Mm-hmm.
You know, what did you do? Who do you work for? What did you see? I came out. I picked up the cartridges.
The
that were
technical
the same.
witnesses.
Right.
Yeah.
And that is going to be 80 or 90% of the people. Now, what's going to be critical, and a witness is called, they're examined directly by the state, in the state's case, then they're subject to cross-examination by Mr. Arputlian and Mr. Griffin, or any other attorneys that are working with them. And that is the process that goes that way, okay, for however many witnesses they have. Is it 20? Is it 30? Is it 50? We don't know. I think one linchpin here, just in my opinion, is, will this be more of a circumstantial case? I want to talk about this for a second.
Mm-hmm.
Will this be more of a circumstantial case because to my knowledge, nobody saw Alec Murdaugh fire the weapons. To my knowledge, he has not told anybody in a confession arrangement, I shot them. So they're going to have to build a case showing this is what happened. There's no other reasonable explanation than this, okay? If it's a circumstantial case, then you're going to see a lot of questioning about the conclusions drawn with the circumstances. How positive are you that cell phone tower was hit at this time? Now, there was a pretrial motion about alibi, okay?
Mm-hmm.
When did it happen? How far can the state go there? And then that's going to come down, if it's a circumstantial case, motive is going to become very important.
Mm-hmm.
Now, we could talk for days about it, but I know that we don't have that kind of time. Rule 404 in our South Carolina Rules of Evidence governs something called prior bad acts. That's ACTS, prior bad acts. And basically they're excluded. And I'll give you an example. Let's say somebody's on trial for shoplifting. They've got 4 shoplifting convictions before. It generally does not come in.
Because then you would assume they did it.
Right. You say, hey, of course they did it. They've done it 4 times before, okay? We like to try the cases on the merits and on this case,
mm-hmm.
which is what makes our judicial system probably the best in the world that
mm-hmm.
I've seen. We're going to try it on this case with admissible evidence, and we're going to focus on the facts and circumstances here. We're not going to talk about anything else that happened in your life. We're not going to talk about, I'm just being hypothetical, a drug conviction that occurred that, this is not a good person.
Right.
Okay? We're not going to do that. We're going to give them a fair trial here on this case, on these facts, in this venue, in this scenario. And so while the prior bad acts are generally excluded, there are exceptions. Common scheme or plan is one exception. If that's what you're offering it for, the judge makes the decision about whether or not you can get into that, whether or not the state can get into it. Here we have, and this, let's just say this, it's a very convoluted case, to say the very least. I mean, we got this boat crash, which was civil, but also criminal. Then that ended with the unfortunate death of Paul and Maggie, certainly, of course. And then it rolled into this tragedy that occurred, and then investigation began regarding misappropriation of monies.
Mm-hmm.
And I believe that at this point, I want to say there's 79 indictments against Alec.
Yeah, at least.
Over monies not being properly distributed with settlements of cases or verdicts from cases and things of that nature, about $9 million. Would he financially have benefited from his wife's death? I do not know.
Mm-hmm.
I don't know, and I don't know what evidence may come in, but that motive is going to be more important in a circumstantial case. It's always important. I'm not trying to say it's not important, okay? But it's going to take on a bigger role in a circumstantial case when you're saying we don't really have any other reason to explain what happened than he shot both people. But why? Why would he do this? And getting into the motive, how far Judge Newman allows that to happen. Does he allow that to be touched on? Because remember, he's been charged, but he's not been convicted. So he's just simply been accused. He's presumed to be not guilty. That's going to be a very interesting and frankly a very difficult decision for Judge Newman to make. How far will he allow them to go? How far will he allow the state to go if that, and from everything I've read, the state feels very solidly that they're going to put motive into this case.
Yeah.
So I think they're planning on it. And there have been several different theories of motive, but the one that appears to me to be the most straightforward and logical, Will, is would he benefit financially?
Right.
Then you have the whole situation of what was the status of the marriage.
Right. A lot of people have talked about that.
It's been stated that she was living separately. It's been stated that she had seen a divorce attorney. It's been stated that there was an investigator involved, and so monitoring Alec Murdaugh's movements and things of that nature. So those are going to be some very tough questions. Judge Newman is a very experienced, seasoned, and veteran trial judge, and so far has done an excellent job. He's got to control the media, but let's go back to the timeline here. Generally, a break of some type is taken after the state has finished their case. Expect the defense to make motions of dismissal, saying that even viewed in the most favorable light to the state, they've not proven the case. Those are often denied, okay? And then this defense, which is another linchpin moment, is do they put a case up, okay? Do they put up 10, 12, 15 experts? Do they put up 5, 7 people to establish where Alec Murdaugh was? And of course, the biggest question, does he testify?
Right.
Does he testify? What's great about him testifying is he gets to tell his story. The bad side of that is he gets to get asked questions too, okay? And so that's going to be a big, I'm sure, something that Jim and Dick are talking a lot about, and of course, and Alec too, I'm sure, about whether or not what can we gain, what can we lose, and what I generally do in those situations is just get out a legal pad and here are the positives, here are the negatives, and let's look at it.
Well, we know he's given multiple interviews to the State Law Enforcement Division, SLED.
Right.
We know that in one of those later interviews, he was confronted with a discrepancy in his timeline for where he initially claimed to have been.
Okay.
And we're told that when confronted with that discrepancy, that he initially expressed shock, and then corrected the investigators and said, well, no, that's not right. I wasn't there at that time. And then they said, no, Mr. Murdaugh, we've got this video evidence.
Right, we've got it. We were taping the interview.
So that could be interesting if they do put him on the stand. But again, we talk about whether you lie about your whereabouts or whether there may even be forensic evidence placing someone at a particular place at a certain time, or that geofencing, geocaching evidence.
Sure. DNA type things, right? Of course, yeah.
But they've still got to prove, for example, we have no weapons in this case that we know of. No weapons.
None that I've been made aware of through following the case itself through the news media outlets. No, there aren't any weapons.
And
that's why I've talked so much. I didn't mean. I'm sorry for interrupting.
No.
You. That's why I talked a lot about circumstantial. Is because just what you said right there. There aren't any weapons. And there are a lot of things that aren't there. So they've got the state, through some very fine lawyering and great attorneys, they've got to build everything they can to say this is what happened. There's no other logical conclusion. This is what happened. And that's why motive's important. And that's why, when I say it's important, I'm not making the decisions, but that's why motive may become a big key. And how far will Judge Newman allow that to go? We don't know. Yeah. We don't know, but they'll get a fair. I've always had wonderful dealings with him. I know he's very well respected. The defense decides if they're going to put up a case. Well, I'm going to finish this line of questioning with you. They decide if they're going to put up their case. The motions are then renewed again. The judge typically takes a break. In a short case, it might be for lunch. Okay. In a longer case, it might be it's 3:30. We've had a long day. We've had a long week. You know what? We'll see you tomorrow at 9:30. That type thing. And then closing statements take place. Each side gets their chances just like in the opening statement, except this time they're not speculating on what's been said or what's been placed into evidence. They're talking about it. They're talking. You saw Exhibit 14. You saw Exhibit 31. There's a problem there. There's a discrepancy there. And the job of the defense attorney is, of course, everybody said, well, of course, the job is get a not guilty verdict. Well, that is correct. In Europe, there are three forms of verdict. There's innocent, there's guilty, and not proven. Okay? In the United States, we have merged innocent and not proven into not guilty. So when someone's found not guilty, what you're saying is, what in the eyes of the law, what the jury is saying is, we do not believe there's enough evidence here to convict this person beyond a reasonable doubt. I have a hesitation about this. That doesn't mean that I don't maybe suspect. Now, there's a jury charge, I'll talk about that in a second, where our Supreme Court said suspicion, no matter how strong, can never be the basis of a conviction. So I may suspect that you stole that car, but I just don't have it in my heart. I just don't see the evidence there. I think he did it, but I don't have the evidence I feel like to convict him beyond a reasonable doubt. The last part of the case will be the judge charging the jury. That is where Judge Newman reads the jury the law. What is murder? Okay. We know the death penalty. We may touch on it if we have time. We know that's not going to be sought. He will tell them that. He will talk about something called the credibility of witnesses, where he says, well, he will tell the jury that you can believe all of what a witness says. You can believe part of what a witness says. You can believe none of what a witness says. But if you think they're lying about one thing, you may think they're telling the truth about the other. And you don't have to make your decision. If a witness answers 100 questions and you say, I think he's lying, I think she's lying about, the questions around 50 or so. I just didn't believe any of that. They still may believe the first part and the last part. And the judge will tell the jury that. They will deliberate. We do require unanimous verdict in South Carolina. I mentioned Europe before. I'll mention them again. They go with majority verdicts. So they're comfortable at 10-2, 9-3. Yeah, they are. I mean, they do. They do not make it be unanimous. A judge can decide they want it to be unanimous, but a judge has the latitude in England to say, no, we all been here 6 weeks. 9-3 is going to work for me. Wow. It's different. It's interesting. I was over there for a week and had a wonderful trip. But that's going to be the basic way, the basic flow of the trial. How long will it last? Including jury selection, I'd say 2 to 3 weeks. And our audience needs to remember this too. Judge Newman has other cases. He may have to do some other things. There may be a day during the week where he says, look, I've got to have bond hearings in King Street, because that's where I believe he's from. And I've got to go back there and do that today. So we're not going to have this case today. Okay. But our cases move a lot quicker than, say, California, But when I talk about Judge Newman, I thought also when you were so kind to invite me to come on and visit with you about this case, I thought about Samuel Alito. Now, I'm showing my age now, because he was the judge over the O.J. Simpson trial, and unfortunately it wrecked his career.
The dancing Edos.
Yes, because he could not, there was no way for him to know, or anyone to know, the kind of media crush that was going to happen. We know what's going to happen in Waldoboro.
Right.
It's going to be chaos. It's going to be a circus. It's going to be the Lindbergh trial. I'm showing my age again. And Judge Newman is going to make decisions about the press. I know that's important to you and your career and what you do. He's going to decide how many people can sit there. Another big question is going to be cell phones. Some judges, I've made the mistake of not turning off my cell phone, going into court, and then having to pay $250 45 minutes later to get it so I could go back to my car again, because it went off. Yeah. So you may see legal pads. I don't know. They're just a lot. It's fascinating. Yeah. I know. I keep referencing that legal pad you've got there. Yeah. But it may be legal pad. It may be legal pads and pens, because they're loud. If we're in here and we're very, very quiet, You can hear those. You can hear the clicking on some of the devices.
Sure.
You can hear it, and judges do not want juries to be distracted.
Right.
They want them to be very focused on testimony and on the questions. That's why jurors are not allowed to take notes in South Carolina, because I don't want you writing something down and missing something else that's important. Okay.
Or scribbling and
exactly.
daydreaming.
Or scribbling or daydreaming. Exactly. Whatever you may be
drawing,
doing,
God knows
drawing
what.
somebody or something, and so that's not allowed. So it's going to be riveting. There will be it's probably going to be a lot like the Kentucky Derby. The two most exciting, what is it? The 2 minutes is the most exciting in sports or whatever.
Yeah.
And then but they cover it for 8 hours. So, there's 7 hours and 58 minutes where there's not a whole lot going on. And then there's 2 minutes when you're riveted to it. There'll be some boring moments, but there'll be some exciting moments as well.
Any predictions for where this thing could go? See,
absolutely
you'll sit on that hot seat and weigh in on that.
I'll tell you what, I would not bet a nickel one way or the other. I just don't know. I mean, it's going to depend on, I think motive's going to be, I think that's going to be a linchpin about how far Judge Newman allows the motive, the state allows them to get into motive.
Because as you mentioned,
because of the financial crimes,
the motive goes into
that he's been accused of.
Prior bad acts.
Correct.
And all that.
The prior bad acts and that balancing test. It wouldn't surprise me to see him at all, and it would not make me think any less of him to say, you know what, we're going to stop right here. We're going to reconvene in the morning. I'm just going to give this another 8 hours of thought about this because it's going to be critical. It's going to be critical because he's not been convicted of that. Yet it could provide. I don't know if he financially benefited at all from. I think it's been established, Will, that Paul did not have anything, that his estate was empty. I think that's been established.
That's accurate.
But I do not know about Maggie's situation and what she knew, or, maybe it wasn't money. Maybe it's the fact that now she's finding out about maybe what's been going on potentially at PMP.
So you talk about legal pads and notes and things. The one thing that I've written down that from this conversation that I'm really taking away that I hadn't thought of before was just how much influence, just how much discretion, and just how much of a weight is going to be on Judge Clifton Newman regarding all these pretrial motions, the admissibility, and then decisions during the trial, motions you said being made during the trial. I mean, he's got just the weight of the world on him here, doesn't he?
It was shorten his life.
Yeah.
I probably shouldn't have said that, but I mean, it's that much pressure.
Yeah.
But he's a strong man,
yeah.
And it takes that kind of person. And I'll tell you something else. I'm very proud of our bar in South Carolina, and I think that it will be. We've got some of the finest attorneys of our state that are going to be a part of this case. We've got an excellent judge, and I think that it will be. I just think it will be seen as very professionally conducted. But how in the world this is going to come out, I don't know. There's so many dynamics about Colleton County and how long they've been there. They're talking about the Murdaugh family. And unfortunately, whoever killed these two people, the savage way that they died is so bad. It's just, I've never seen a case like it.
Yeah.
And we probably won't. Hopefully we never see another one like it again.
It has shaken a lot of people, and
it has.
And again, not just the nature of the crime, but also all of the background. There's a huge piece in the New Yorker just this week about sort of the background of the Murdaughs and the institutions down there in the 14th Circuit. Obviously, we've seen HBO, Netflix, all these documentaries coming out as well.
Yes.
Have you ever seen a South Carolina case draw this kind of international?
No, I haven't.
Mm-hmm.
I got to thinking about that when you called me up, I think last week, and said, let's sit down and visit and talk about it. I got thinking about that. The only other case I can think of recently that garnered national attention was when Andy Savage represented the officer
Slager.
In Charleston.
Michael Slager.
Right. Okay. You know more about it than me. When the African-American gentleman was on video, it appeared to be running away from him. I wasn't at the trial, and Andy was his attorney. I know that case was covered nationally, but nothing like this. I mean, this has an incredible regional appeal. It has a big national appeal, and candidly, I think it has an international appeal. Mm-hmm. So no, I've never seen anything like this in South Carolina. So I know Judge Newman will do a fantastic job, but I certainly don't envy him one bit. I mean, he's got a lot on his shoulders.
Got some tough decisions ahead,
A
doesn't he?
lot of tough decisions with some really good lawyers that are going to make some excellent arguments. So it will be very entertaining. I guess what I was trying to say earlier to our audience, Will, is there may be moments and days when people are like, I don't know what's the big deal is with the Murdaugh case. And I watched it. I mean, nothing really much happens, but it'll be Mercury. It'll be sitting there right on that table, and then all of a sudden it'll just start moving.
Yeah.
You know? And that's what our audience needs to expect. But I don't. But as to how I think it might turn out, Will, I just don't know. There's so many, and it is so different. Richland County, we don't know everybody. Mm-hmm. We can go out to the mall and not see anybody we know. Greenville County, where I'm from, we can go to Haywood Mall, and I can walk through there days on end and never see anybody I recognize. But in a small county, it's so much different. The dynamics are so different. It doesn't mean that every single person knows every single person, but it's almost that way. So one day, on a personal note, I'm not going to say who the judge was. Fine gentleman. I was a prosecutor and felt like the verdict should have been guilty. The verdict was not guilty, and I was down about it. So, and I was young, I was down about it. And so he pulled me back in his office. He said, look, in small areas, small counties, he said, you don't know, that lady may not want to see her grandmother at the grocery store and not have to, and be embarrassed that she convicted her daughter or granddaughter. And you have all those kind of dynamics in a smaller area. It is so different than Charleston, than Greenville, than Columbia. It is. And we'll just have to see how it unfolds.
It's going to be fascinating, man. And I'll tell you what, the specificity you're bringing to this and sort of the detail and that step-by-step, just amazing insight for our readers and audience as they get ready for this.
Well, I hope so.
Thing. And
well, it's complicated, and
I
hope that
I've learned a lot, and I've been covering, just sitting here with you the last couple minutes. I've learned a lot, and I've been covering this thing for the last 2 years. And it's
I know, and you've done and congratulations to you and your staff and everybody that's a part of FITSNews in terms of the coverage that you all have given. You've done a tremendous job, and I know that you're proud of the work that you and your company does.
Man, I'm grateful for that, man. Steve Sumner, everybody, Sumner and Todd, upstatedui.com. By the way, you've been on our show before. I can't help but plug the good work your guys are doing up there in the upstate. So for all your needs on that front, upstatedui.com. Check out the site. We're going to put it up on the screen here to make sure you've got it. But Steve Sumner, thank you for coming in. Will you be, if we're to get you on the phone maybe during the trial, would you be willing to maybe bounce
absolutely anything?
Can we get you down to Walterboro at all? You're going to come down maybe
I don't know if I'll go to Walterboro, but I promise you that I'll take your call, Will. I promise that. And if you want to talk about some insights or not necessarily insights, I'm not trying to say I have those, but if you want to talk about maybe, Steve, what's going on here? We don't know, because we still use Latin words sometimes, like Murdaugh and things like that. What does this mean? What does that mean? We want to try to make it to where our audience understands everything that's going on. And there is obviously, and I'm not trying to go on too far, obviously, in the last 10 or 15 years, we see a big focus on transparency. If you feel like I can help in any way, you just give me a call.
Absolutely. Well, you've shed a ton of light on this thing today, man. Appreciate it as always. And come back anytime, brother.
Thank you.
Yes, sir.
Thank you, Will.
Appreciate it.
All right.